your host and the consumer quarterback, Brandon Rhymes.
And yes, welcome to the Consumer Quarterback Show. It's a great day here in Tampa Bay, helping you serve the community as a consumer advocate, helping you with your buying decisions, making you more street smart here on the Consumer Quarterback Show. We got attorney Milly Athanason in studio. We're going to talk about modification procedures in the family law aspect here coming up as well on the Consumer Quarterback Show. Save our hotline number at some point. You may need us. You can reach us on the hotline at 727-263-3707. You can call or text that line. It's an off-air number, 727-263-3707. And follow us on socials at CQB Show on Instagram and Brandon Rhymes 1 as well. Our YouTube channel, over 2,000 videos now on our YouTube channel. Been doing the show for almost 10 years now. August will be 10 years on air. So real excited about that and a lot of the growth around our Platinum MVP team at Keller Realty, also Livian Coastal Elite. So we always like to feature our real estate listings live on air and help our sellers profit more and sell faster. We got a brand new listing. This is a $13 million co-listing that we have with the Meraki Group out of Orlando. Pebble Creek Court, Four Corners. This is in Orange and Osceola County. What we've got is a 100-acre listing here, prime development opportunity in Orlando. You're only 10 minutes from Disney World, Universal Studios, SeaWorld, downtown, and more. So you could build short-term rentals here, residential property, perfect for development here in Orlando. Pebble Creek Court, Four Corners, Florida, that is, close to Orlando, Claremont, Florida as well. brimes at kw.com for more information. BRIMES at kw.com for more info on that real estate listing. We also got a new land listing here in Tampa Bay. This one is 17313 North Del Mabry. This is a property that we've got listed, vacant land parcel. Build your dream home on this waterfront lake community, 1.02 acres, undeveloped land, Crenshaw Lakes community, opportunity to build a lakefront home, build your dream home, and you also have no CDD or HOA fees on this beautiful property at 17313 North Del Mabry Highway in Lutz, Florida. And you can see all of our real estate listings at PlatinumMVPTeam.kw.com.
And yeah, I'm racing my class to those saving our ass overseas.
All right, attorney Milly Athanason, welcome back in. Great to see you.
Thank you. It's always good to be here.
Excellent. My pleasure. And when we look at this family law, it's an issue where, unfortunately, it's above 50% now, and it has been for some time. A lot of these blended families, you see a lot of blended families and, divorces out there. There's a lot of divorces going on, and a lot of times there's children involved, and it's, heartbreaking in a lot of cases, but people decide that there's irreconcilable differences is what they always quote, right? That's the word, irreconcilable. So tell us a little bit about what you're seeing in that space of your practice.
Well, anytime you start seeing the economy taking a shift, you're going to also see an increase in filings in the divorce realm as well as in the modification realm. So in a divorce and in straight out divorce, all of the issues are on the table. So, you've got the issue of the divorce, you've got the issue of children, where they're going to be living, going to set up a parenting plan, you've got child support, alimony, equitable distribution, attorney's fees, all of those issues. When you're doing a modification proceeding, it's often limited. Usually it's a modification of alimony, child support, or of the parenting plan, because equitable distribution is usually not subject to modification. So what happens is the economy goes bad. People that had a really great paying job, let's say, maybe they lost their job for whatever reason, not through their own fault or just by walking away. They just lost their job, company may be downsizing. There's a lot of things that can happen. And so the amount of alimony and child support, let's say, that they were able to pay for previously, they can't pay for now. And or there may be a situation where kids are on a certain schedule, but something happens with the kids. Let's say one of them falls, ill, or one of them joins some athleticism program where they're out doing games and it's competitive as opposed to just like a recreational type league. So it may have to alter the time sharing or the visitation schedule. So how do we go about that? How does that happen? Well, it's called a modification proceeding. Obviously, I always encourage my clients to talk to the other spouse first to see if there's something that can be worked out, if they can make an agreement, because certainly that's number one, cheaper, and number two, it forces the parents to talk to one another to do what's hopefully the best thing for the child or the children. If that doesn't work, well then obviously we have no choice but to file. The standard that you have to meet is different for a divorce as opposed to a modification. When you're looking at a modification proceeding, you have to show that it's a substantial change in circumstances that was unanticipated by the parties at the time the original divorce was entered, and you have to show that not to make that change could be detrimental to the children. So, you have a much higher standard of proof than you do in a regular divorce proceeding. So, for example, just because somebody got a new job doesn't necessarily mean, and they got a raise in their job, doesn't necessarily mean that the child support automatically goes up. We would still have to run the guidelines and make sure it meets the statutory criteria of the 15% or $50 a month more to qualify as a substantial change in circumstances.
So that's the
for
the
child
barometer
support.
there is 15% or $50 more.
Yeah, and so
it doesn't seem that substantial to me. $50. I mean, come on.
Well, if you're a single parent raising kids, $50 can mean a lot to somebody.
Yeah, I guess.
I mean, unfortunately,
but they're going to drag everybody back into the courtroom. For $50.
It doesn't. You're right. It doesn't make sense. It would make sense because they got to pay attorney's fees and court filing fees and so forth. So I always, we try to run those numbers when people come in, and I ask, okay, well, what's going on? What happened? And we'll try to run some numbers to see if it makes sense for them to even make a modification or to ask for a modification. So those are things that, now with child custody, it's a little bit different with parenting plans, because if things happen in the children's lives, which happen, and you can't, if you got divorced, let's say when the kids were 3, of course things can change when the kid's 12. I mean, that's just kind of commonplace. And while you anticipate that they're going to get older, you don't necessarily anticipate that they're going to have changes in their life. Maybe they maybe they're a concert cellist. I mean, who knows what they do. But what you should be doing is speaking with that other parent to see how is that going to work for the children.
Yeah.
Children at all times have the right to have a relationship with both parents, and it's up to both parents to foster and encourage the relationship between the child or children and the other parent.
Right.
And my experience, Brandon, has been, and I always tell people this, the parent that goes around bad-mouthing the other parent, that's the parent the children are going to have a problem with.
Yeah.
The parent that's neutral, that encourages a relationship, that gives the other parent the benefit of the doubt on things that may be said, that's usually the one the children are going to trust. Because they're going to say, well, my mom or my dad, whoever that parent is, wants me to have a good relationship with the other parent. They know that I'm a part of both of them, and it brings them a sense of security. What happens oftentimes in these things, I call it the popular parent syndrome, where you feel like a reject because something didn't work out in the relationship. So now you're dead set on becoming the popular parent.
The friend.
That is the worst thing you can do, They don't need friends. They they get friends at school or in their neighborhood. They need parents.
Yep. They need discipline. They need to have rules. They need chores. They need accountability.
Absolutely.
Let me ask you on that same note, how many times do you see this happen, today, in these days, especially when it comes into the teen years, 16, 17? Are you finding that type of scenario plays out more often than not?
It happens a lot. The difficulty when we've got a 16 or 17-year-old, if a court believes that a child is of sufficient age and maturity to have input, the court can appoint a guardian ad litem, and the guardian ad litem will then go ahead and interview that child, and then their opinion or their feelings could be stated to the court through the guardian ad litem.
Right.
If you want, because a lot of people ask me this, well, why can't my child just come in and testify? Courts highly frown upon children coming into court and testifying, and you should never make a child have to choose in a courtroom what they want to do with regard to each parent. That just puts a great amount of stress upon a youth. That's just not right. So what we normally do, if you do want to do that though, if you're set, like you want your child to testify, I have to make a motion before the court, and the court has to, hear the motion, and they have to agree that the child can testify. If they agree that the child can testify, it's usually done on an in-camera basis, which what that basically means is behind closed doors with just the child, the two attorneys for each side, and the judge. Because obviously we don't want the child to feel pressured to say something because the parents in the room.
Because they're in the same class, same room. Yeah.
Exactly. Yeah. But more often than not, the court prefers to appoint guardian ad litems who are also attorneys that don't represent either party, that don't really have a dog in the race, if you will.
Right.
And they go out, and they're kind of the eyes and ears of the court. They go out to each of the homes, evaluate. They'll meet the child or children at school, so this way they can speak freely with the child or children apart from the parents.
That's a good idea.
Yeah, so that's what I do when I do GAL work. I always go to the school to meet with the children, because I know at that point they're not pressured by either parent. It's just they're in a neutral atmosphere, if you will.
Yeah.
And then they interview we interview school personnel. We go to each house of the parents' houses, interview them, and try to get a feel for the situation so that we have information to give the court that can hopefully help the judge render a decision on that issue.
Yeah.
But with older kids, it is definitely challenging. And, custody battles, Brandon, are the most expensive to get into. And so you have to balance that. Okay, if a child is 16 or 17, by the time you get to have a trial date, is that child already going to turn 18? So is it worth it to invest all this time and money into it?
Right.
And that's a personal case-by-case decision. I mean, there's no correct answer on that. You've got to sit down with the attorney, go through all the facts and circumstances, and evaluate if it's a good move. And so that's what I try to do with the clients, because I don't want them to spend money filing lawsuits that, by the time they get through, the child's going to turn 18. That doesn't benefit them.
Right. Yeah, it makes a lot of sense. Milly Athanason here on the Consumer Quarterback Show. Athanason Law, 833-ASK-MILLY is her phone number as well, 833-ASK-MILLY. We're going to take a quick break. We're going to come back more with attorney Milly Athanason. We're going to continue this conversation. Maybe ask the question also, differences between mediation, arbitration, and maybe we'll touch on a little estate planning as well as personal injury law. She does all three. Milly Athanason here on the Consumer Quarterback Show, consumerqb.com.
Brandon Rhymes, online at consumerqb.com. Brandon is Tampa Bay's #1 consumer advocate for real estate and financial advice. Call Brandon today at 813-917-1894.
All right, welcome back. Thanks for sticking with us here on the Consumer Quarterback Show. It makes our day when we get calls. We love it when you engage with us and reach out and support the local economy, support our great expert contributors on the program, and also the real estate company. We greatly appreciate that. 727-263-3707. And it's a local number at 727. It's off-air line as well, 727-263-3707. Call or text that line with any questions, comments. Also, brimes@kw.com. You can email me at brimes@kw.com as well. We got a listing here at 12290 101st Street in Largo. This is a great opportunity. It's very rare to have this much vacant land available for building and development in Largo in Pinellas County. We've got 11 acres in the heart of Pinellas County. 5 acres are buildable here, and we've already completed a feasibility study that says 22 waterfront homes can be built or up to 43-unit townhome community. Great opportunity at 12290 101st Street in Largo. That is beautiful. Pinellas County, great development opportunity. And we'll stick with the land idea here at 2817 Gulf City Road in Ruskin. 2817 Gulf City Road is another waterfront community here. 23 acres on the Little Manatee River with access to the Gulf of Mexico. Check out the beautiful photography compliments of Fabre Frameworks, the official real estate photographer of the Consumer Quarterback Show. This is a great opportunity. Deep water access into the Gulf of Mexico, fishing, building potentially for townhomes or condos. Beautiful opportunity. 2817 Gulf City Road in Ruskin, Florida. You can see all of our real estate listings online at platinummvpteam.kw.com.
This is God's country.
All right, Milly Athanason in the house, attorney Milly Athanason. That is. Let's talk about that. There is, in lieu of going straight to trial, there's ways that you can do these kind of in between style opportunities of mediation and arbitration. Would you mind describing the difference?
Sure. So mediation is required pretty much before you ever get a trial date. In other words, the court's not going to give you a trial date until you've attempted mediation, unless somebody files a motion to do away with the obligation to go to mediation.
Okay.
And the reason for that is because courts feel that if the parties can come to their own written agreement, that it's usually going to be far better than what the judge is going to order. Because you got to remember, you go to court, judge is going to hear each of you talk, for a brief period of time, and then be making decisions that's essentially, they're going to affect the rest of your lives.
Mm-hmm.
So if you can make those decisions yourself, obviously that's better for you. You have more control in the outcome. Mediation is a perfect place to exercise that control over the outcome. So in mediation, each party goes with their attorney typically to the mediation conference, and the mediator is a third attorney who's a certified mediator, whether it be in family law or circuit civil, or depending on the case that you have. But if it's a family case, it has to be a certified family mediator. And the mediator is obviously a neutral person, doesn't have a dog in the race, and they go back and forth between the two rooms, if you will, and try to get the parties to meet in the middle. And so if the parties are successful and reach an agreement, the mediator will reduce it to writing, will give it to each of the parties to sign and their attorneys, and then it gets filed with the court. And then the court just approves the mediation agreement and orders the parties to comply with it, and then the case would be resolved. Now, if it's a partial mediation agreement and you only agreed on some of the issues and you want the rest to be decided by the court, that can be done too. Nowadays, the mediations are pretty much done on the Zoom platform. Ever since COVID, that became kind of a necessity. And since that, now that we're back, if you will, without COVID, then it's still being done on the Zoom platform because the attorneys and the clients found that it was more convenient for them to attend a session or a whole day session, if they were, depending on how long it is, through the Zoom platform. And then what's happening, so the mediator, if you get an agreement, we circulate it through DocuSign and everybody signs off on it.
There you go.
And arbitration is a little bit different, and there's two types of arbitration. There's binding and non-binding.
That's what I was going to ask.
Okay.
So mediation, what you just said, is non-binding.
Well,
right?
It's binding if you reach an agreement.
If you agree, right?
Yeah, and if you sign the mediation agreement. If you don't agree, you're not under an obligation to agree if you go to mediation. If you don't agree, you can reach what's called an impasse, and then that means nobody agreed to anything. And the mediator just files a notice of the impasse, and that will allow you to go get your trial date so that you can set it for your final hearing.
Okay.
So arbitration is a little bit different animal. That's kind of a more quasi-judicial proceeding. So with arbitration, you're asking a panel of arbitrators typically. It could be either one arbitrator or three arbitrators, depending on the type of proceeding. And what happens is you present your evidence, your documents, just like you would if you were going to court. And you're asking that panel to make a decision because they put the decision in writing. If it's a non-binding arbitration, typically the parties have 30 days from the day the arbitration award is granted to file with the court to have that set aside and to proceed with the regular court proceeding. If after that time they do nothing, then that arbitration award stands. Okay. If it's binding arbitration, you're going into the arbitration hearing with the notion that it is completely binding. You can't go back to the court and say, I didn't like those arbitrators or what.
Well, what's an example where do I have the right to choose, and what's an example where I may have the right to choose or I may not? It may be, no, this is going to be binding because we have to have a conclusion to this. Is there
Yeah, so usually the standard is, it's not required under the law, but usually if the parties have a contract that requires that any dispute in the contract be submitted to arbitration,
Right.
then the court's going to enforce that because you signed a contract saying that you're willing to submit yourself to either binding or non-binding arbitration.
Yes.
If you have a dispute and you can't work it out amongst yourselves.
Right.
So it usually comes up in more in contract action.
I think real estate contracts have that component in there.
Yes.
Some of the contracts do, yeah.
Yeah, and so usually if it's a one panel arbitration or if it's one person arbitration panel, the parties have to agree on the arbitrator. If it's a 3-man panel, then each side picks one arbitrator and then the 2 arbitrators pick the 3rd arbitrator.
Okay. And I know that's one thing to be careful of too, or at least cognizant of, is sometimes like the big, say for example, a cell phone company, they're going to have an ongoing relationship with the mediators or the arbitrators. So that could put the person, the customer, at a disadvantage because the mediators, arbitrators, they know they have an ongoing relationship. We might want to side with this big company. That's one of the faults I see with that type of a system.
Yes.
30 seconds back to you, Millie. Summarization, and how do you want people to connect with you?
Well, absolutely. So you mentioned my contact information at 1-833-ASK-MILLY. We have 2 offices, one in Holiday is the main one at 2318 US Highway 19, and one at Spring Hill on Deltona Boulevard. And our office main line is 727-376-9100, and please call us to set up a consultation.
Consultations, estate planning, personal injury law, as well as family law.
That is correct.
All right. 833-ASK-MILLY. Milly Athanason, always a pleasure having you in.
Thank you.
And thanks for breaking that down for us. I know that can get confusing for some people.
Yes, thank you.
And awesome. Well, find us online. We'd love to connect with you online at Brandon Rhymes 1 on Instagram, Twitter, all the major sites. Our YouTube channel is a great resource, a plethora of resources on our YouTube channel as well. Brandon Rhymes Realty, over 2,000 videos there. And we're going to take a quick break. We'll be right back. Check us out online, consumerqb.com.
Hey, this is Grant Cardone, and you've been listening to the phenomenal Brandon Rhymes, the Consumer Quarterback Show.